of a rainstorm here.
I saw the street is wet a little bit, but I was down in Prince Fred.
We're live. We're live. We're live, yes.
All right. Call to order. This is the regular meeting of the Ethics Commission of the Town of Chesapeake Beach, Maryland, properly called. All members are present. Also present is the Commission's counsel and the Commission's clerk. So we have a quorum, and the meeting is now in session. Please join me in the Pledge of Allegiance. First agenda item is the approval of the agenda. Agenda has been distributed. Is there any objection?
None.
No, unanimously accepted, approved. Now, the next agenda item is the approval of the minutes of the previous meeting, which was held on June 13, 2022. The minutes have been previously distributed. Are there any objections to the minutes? No objection. The minutes are unanimously approved. Next agenda item, it's item B, review of the public disclosure statements. The bulk of the statements have been previously distributed, commented on. There were a few or corrections that had been identified. And Sharon, I believe we have received responses from all persons concerned.
Yes.
In addition, there have been two additional appointments of two additional persons who are obligated to file public disclosure statements. One is Stephen Sharp, was appointed to the Board of Appeals, and Ms. Kelly Horn was appointed to Planning and Zoning. We have their public disclosure statements, and I reviewed them together with counsel. It seems that Mr. Sharp's disclosure statement is incomplete in Form A, real estate owned. There are some gaps in the information provided. One is the question about land use when acquired. He has stated own. I suppose what he means is that it was a residential property, but that should actually be stated. Also unclear, incomplete is the answer to the question, how was the ownership acquired? A rights loan. What he probably means is it was acquired by purchase and financed with a mortgage. He does list a mortgage lien holder or co-owner, but it is unclear in which category of these two categories that person falls. It looks to me like it's the spouse, which is probably the co-owner, but we don't know the lien holder. And also, the form does not disclose the seller from whom the property was acquired. So I suppose, Sharon, you would do the usual and send your reminder letter asking for this information. The second of the most recent, as yet unreviewed disclosure statements is from Kelly Horn, appointed to Planning and Zoning. And here also, with respect to item A, real estate, real property owned in the town, the attachment is incomplete. We don't see land use when acquired, how ownership was obtained, from whom, and are there co-owners or lien holders. And Ms. Horn should also receive a reminder to provide this this additional information. I didn't see any other deficiencies in the disclosure statement. Okay, this should take care of point 4B of the agenda, review of the disclosure statements. The next item, C, is the review of pending proposal to amend the ethics ordinance. I had sent a brief memo to everybody, dated September 12th, in which I state that it is my understanding that there are only very few items that we still need to discuss. The whole amendment had been previously presented to the town council. That was done by the previous chairman back in January, and the mayor raised very strongly worded objections to a number of points, all of which were based on his concern that they created obstacles to people's willingness to serve in especially appointed capacities for the town. And I suppose, using perhaps my memo as the sort of the roadmap, I suppose we will discuss these three matters. I should say right now, lest I forget, that there is a fourth matter that I would like to change. The proposal that had previously been submitted to the council made a change that throughout the ordinance, the terminology would change with respect to the disclosure statements. The current ordinance calls them financial disclosure statements, which is the terminology used by the state. And the reason for the change is that the information that is to be disclosed is not limited to financial information. It also includes other matters. That is true enough, in my opinion, but I would nonetheless prefer that we stick with the state's own terminology and continue to call them financial disclosure statements. That, of course, that's what also our supervisors at the State Ethics Commission would call them, including in their proposals for amendments that we will come to later in this during this meeting. Can we put this point to bed? I mean, would everybody agree that we stick with the existing language and call the babies financial disclosure statements rather than
Agreed,
public
yes.
disclosure statements?
It makes sense to be consistent with the state. I'm just wondering, the reasoning you presented is sound, that is beyond a financial.
Well, there were, from the records I could see, there was no discussion at the council's working meeting when our proposals were presented. No discussion at all about this change of terminology.
For our town council, you're referring to.
And so I think we can
My
go
question,
back to the existing wording because the whole thing will have to be presented to the council one more time.
my question is that, is there a way to make the recommendation to the state ethics commission to change the wording, because it is more appropriate? Is there a channel to make that recommendation to change the name for the state ethics commission? Is there a way?
Well, a couple things. Number one, the town ethics ordinance contains questions that are not included in the state forms and are not included in the state law. And the State Ethics Commission, I don't think would have the power and authority to change the terminology because, again, it all emanates from state law, and the Ethics Commission is only implementing state law. So the state forms can include only requests for financial information, so they quite properly are financial disclosure forms. But again, the state forms do not include a number of the questions that are included on the town form.
So the state form is limited to financial questions, financial
Yes.
related questions only,
Yes.
is what you're saying.
Okay, what is, let's come
I
to a
agree. I mean,
consensus.
I do agree to be,
Do we stick with the existing proposal and call them public disclosure information, a public disclosure form, or do we follow the state terminology? Even though in our case it would be imprecise because we include non-financial information.
Correct, yes.
I personally think that a public disclosure is more appropriate in our case.
Okay. Greg, you.
I agree.
All right, I concede, so we leave the language as
disclosure.
is, as council would have no objection.
No objection.
Okay. The first point to which the mayor objected was wording that bars a covered person from serving as a director or officer of an entity that receives funding from the town. And this has been discussed before. This commission made some modifications to the language which was had been presented to the town. The language is contained in my memo, and I think it's better language. However, we have there's a little wrinkle. Council has pointed out that essentially the same policy objective what could be achieved not by an outright prohibition as under the present proposed language, but by a provision that the relevant person that faces this conflict of interest would not be allowed to participate in any action pertaining to that particular entity. And that would affect, of course, all the elected officials, as well as, I think, town employees, such as, I suppose, the treasurer, the town administrator, perhaps relevant department heads, who would also, no doubt, have something to say about not being allowed to have officer or directorships on these entities. By the way, if anybody wants to refresh their memories, I brought with me paper copies of the mayor's objections. Yeah, you have seen it, but that goes back several months. So if anybody wants it now, I have paperwork here.
Peter, I'm sorry, but I guess I'm missing the point. Is the objection from the mayor that being the officer of a company that does business with the town is not a
yes,
conflict of interest?
What we proposed is that a covered person may not be an officer or director of any entity, and there's a short list, and includes an entity that requests or receives a grant or other funding, including budgetary funding from the town. And the mayor gives one example. One of the council members apparently also has a leading role to play in the volunteer fire department. Fire department receives money from the town, and as the mayor understands our proposed wording, it would mean that council member would have to give up his directorship. I'm not sure whether that is the titles they use, but functionally the equivalent of a directorship at the volunteer fire department, or give up his seat on the town council. Now, personally, I'm very sympathetic to the mayor's point of view. He is the one where the buck stops. He has to recruit people like our gremium here, and he didn't recite any particular experiences where he was turned down, but no doubt he has been turned down by people he tried to recruit. So I understand that he is very sensitive to this point. What I would also like to remind everybody that the mayor has the right to veto a council vote. And certainly to be hoped that the proceedings of the council do not rise to that level of passion where that might be where that might happen. But I think it is good for us. We are not the ones who have the task of staffing or the town's volunteer jobs. The alternative language that council has proposed would perhaps take the sting out of it. If we no longer say, no, you cannot hold that position, and we say instead, we treat this as a conflict of interest situation, which is resolved by the relevant person recusing himself from decisions affecting that particular entity. Congressman Jaworski, not Congressman, Councilman Jaworski would not vote on the appropriation that the town would routinely give to the fire department.
Is that so? Are we making a distinction between being an employee versus a director of an organization? I guess this is maybe the council member who is a volunteer at the fire department. I know him, and I agree with the mayor's concern that eliminating or prohibiting him from participating, that doesn't make sense. But I guess I have two questions. One is that are we making a distinction between employees and directors or not in our ethics?
The proposed language
Proposed language.
talks about prohibiting a covered person who is an elected official or a few appointed officials from being an officer or director or having a financial interest in any entity that does A, B, C, or D, including request or receiving grants or other funding from the town.
Right.
And my alternative proposal, I'm not necessarily recommending it, but throwing it out on the table for you all to consider, is that instead of outright prohibiting holding an officer or directorship in one of those organizations, that the covered person, the council member or designated official, be prohibited from participating in any matter involving the organization in which he or she is an officer or director.
And so that being the case, the incumbent person would have to recuse themselves, correct?
And it would be a prohibition. If they violated it, then it would be a
Right.
violation of the ethics ordinance,
Correct.
subject to sanctions.
I personally like the proposed change, meaning that the person recuses himself or herself whenever there is a discussion related to the organization they have a financial tie in, essentially in any shape or form.
Further discussion?
And that if the commission want to go with that proposal, then I'd have to come up with some modified language to section 25-20. You don't have any specific language before you. You have the concept.
Gotcha.
And if you agree that, yes, you like that concept, then it'll take me a couple minutes, not today, but to put together a proposed amendment to section 25-20.
Well, if we get to that, if it's the consensus of this commission that it would be preferable to adopt council's proposal. And if the vote is no, we keep it as is, then we never reach that
Right.
question, obviously. We don't, with a green room of three, as a matter of parliamentary procedure, we don't need to have a motion, a second, and then a vote. are we in agreement that we would follow council's alternative language, council's proposal?
Or an alternative.
Okay, so that's
Yes,
unanimous. And now we can look at, I think it's somewhere in section 25-20. Twenty-five. Yeah, it's in section 25-20. It's part of the section on participations restrictions of the ordinance. And it reads in part, a covered person may not participate in any matter in which any of the following is a party. And now comes a short list: A, B, C, D, and E. It includes an entity or for which a covered person or other person or a close relative is an officer, director, trustee, partner, or employee. And wouldn't that cover it, Council?
But this is 25-20.
25-20.
So we
then-
don't, in fact, need to amend 25-20, and all we need to do is eliminate the words and be an officer or director from the language which is currently being proposed.
That's correct.
Greg,
yes.
you
we're
think
good.
that's all right? Well, I think we just accomplished something. Now, back to the mayor's objection. Out of the presently proposed language, 25-23, B, in the first line, we delete the language be an officer or director of, so that it reads, a covered person may not be employed by or have a financial interest in any entity that receives funding from the town.
You say that again, Mr. Chairman?
In currently proposed language of section 25-23, letter B, The section will read, a covered person may not be employed by, be an officer or director of, or have a financial interest in any entity. We delete the words be an officer or director of, so that it reads, covered person may not be employed by or have a financial interest in any entity that receives funding from the town. Okay. Mayor's further objection, that's paragraph 2 of my memo. We added a new line item to section 25-27B that deals with gifts, receiving a prohibition of a covered person from receiving certain gifts. And the mayor agreed, but expressed his understanding that this should apply to elected officials only. And I have no particular love or hate one way or another.
And the reasoning for that was what?
Well, there are other decision makers, and take, for example, the director of public works. He commands a whole crew and a lot of equipment. He's in a position to do favors to people. So I think the theory is of that additional language that we put in is we want to eliminate the temptation that somebody says, I have a plumbing problem in my house. Can you send somebody over? And then he gets a turkey for Thanksgiving from that official.
So I understand the motivation to prevent that situation. What was the reason that the mayor said that should not apply to others, non-elected officials? I'm not sure if I understand the reasoning.
Well, one of the drawbacks of exercises like this is the more you legislate, the more additional things you have to legislate. Mayor says if it's a prohibition applying to elected officials, that apparently is acceptable to him. And he is not concerned whether you or I or our colleague here, receives a turkey or whatever. Now, you can take a more moralistic position and say, let's do a flat-out prohibition. It probably can do no harm. The barrier to one of us saying, no, I don't want to appoint my appointment to the Ethics Commission because then I cannot receive gifts from somebody. I don't think that is much of an obstacle. I propose then that we keep the added item 4 in section 25-27B, that all covered, it covers all covered persons, let's say all officials elected or appointed, regardless of their actual function for the town.
I would think so. That's pretty fundamental in my mind.
Makes sense, yes.
Oh, all right. And the last item to which the mayor objected has to do with late fees. Currently, the ordinance provides for a late fee of $2 a day for not filing disclosure statements on time. The previous proposal had been to raise this fee from $2 to $5 a day, with a cap of $500. And the mayor prefers no fee. Off the official record, subsequent to that presentation, there was another back and forth between the previous chairman and the mayor, and which is somewhat unclear whether they agreed on anything. It looks that the mayor said, well, I can live with a late fee, but I want to keep it at $2 rather than up it to $5. And that Phil Keat, predecessor, said, well, okay, we give up our ambition to raise it to $5, but this dialogue does not rise to any kind of official position. So the question here is, would we continue to ask for an increase from $2 to $5 a day, or just leave it as is with $2 a day?
I have a question. How frequently does this happen? Sharon, are you aware? How frequently do people not comply?
And how much money have we collected
Yeah,
over
and
time?
how much money have we collected anyway?
If I may,
I'm sorry.
for the years that I've been working with the commission, it's never imposed a late fee, a fine for late filing. Every year there are a few people who we have to get after to file reminders. Sharon does a good job of that, and eventually they all file. I'm trying to think in the 5 or 6 other ethic commissions I work with, I don't recall any of them ever imposing a fine.
Yeah.
It's in the ordinance because the state is in the state law, and the state probably says you need to have some type of fine as an incentive for people to comply with the law. So it's there more as actually a disincentive to not complying than reality being imposed and collected.
In that
Did
case, I
you
would-
say that the state does require there has to be a? I thought the state did not require a fine.
I could be wrong, Mr. Chairman. That was my recollection, but
Because I believe, just speaking from memory, and I may be mistaken, they gave us 2 model ordinances, A and B, and one of them provides for a fee, but the other one doesn't. And the implication would be that no state law does not mandate that there must be a late fee. Now, my own personal view is, a $2 late fee, it's a bit trivial.
$2 a day.
If you want to make it $20 a day, but then is meeting the filing deadline so important. And again, you can say yes. There's plenty of time for them to do that. And if they are lackadaisical and they don't give us the disclosure forms, then yeah, it should cost them $20 a day.
Considering the fact that it hasn't been a problem in the past, I would just suggest that we leave it alone. It's already there, $2, in case one needs to be assessed that fee. We have never done that before, but if we had to, we have that tool. And going from 2 to 5, yes, it probably gets more attention, but again, it just seems to me that we are trying to fix a problem that doesn't exist.
Exactly. Yeah.
Whether it's $2 or $5, really shouldn't. There's no good reason to do it. $5 is no more of an incentive than $2, I think.
Exactly.
Right.
I mean, among the potentially affected person, they all can afford, a $5 fine for a week or whatever it takes them, as they can afford a $2 fine. And my view, if it's not required by state law, then my own proposal would be just forget about the fines, period. It probably doesn't do anything.
It is already in the ordinance, the $2. Again, just for the fact that has not been a problem, there is a tool for us to use in case we need to use it. It's there. We just leave it alone. We don't make any.
Well, the
changes
easiest
to
thing
it.
for us to do is do nothing.
Exactly. That's what we do.
Leave the ordinance written as is,
Yes.
and don't ask the council to make any change.
Changes. Yes. Drop that suggestion.
Okay, consensus. So we agreed. That concludes agenda item C, I think we are at. Seems I lost my agenda.
This one.
Somewhere. All right. The next agenda item is for D, review new state mandates to amend, all certain municipal ordinances, and that includes our ethics ordinance. The state gave us what I understood and what council understood to be mandatory language. And we have proposed a proposed ordinance, thanks to learned counsel, which would implement that state's mandate. And we can talk about it, but there would be no point in it because the state has basically said, this is what you have to do. And I think none of these changes are likely to pertain to this town. Difficult to imagine a situation, but nevertheless, it has to be in our ordinance. So I think we can simply vote to approve the proposed ordinance as drafted by council and submit it to the council for adoption. Is that what you had in mind?
Yes, Mr. Chairman. If I can, I would like to make just a couple of comments by way of background. What I did was when I received the letter from the state, and I've done this for all 6 of the ethics commissions that I work with, and with yours specifically, I took the mandated changes memo and compared it with the existing town ethics ordinance and determined item by item where we needed to make the changes to the current ordinance, section by section by section, and then came up with the appropriate language. I would say that the language that is in the draft ordinance is at least 95% the same as in the state mandated language. There are a couple of minor changes that I made, not substantive, but codification wise, and also editing type things to make it more consistent with the style of our particular ethics ordinance. The other thing I want to note is that in this memo from the state, there are a number of items where the State Ethics Commission is saying, hey, if you have definitions, you may want to make certain additional changes to definitions. You may want to look at your form, your financial disclosure form, and make these particular changes to your financial disclosure forms. So I think that there's a little bit of work to be done when we get to looking at the forms and getting them ready for next year to make sure that we incorporate any recommended or mandated changes in those forms, from the State Ethics Commission.
Yes, thank you, Fred. Incorporating these changes into our disclosure forms or the instructions to our disclosure forms, that's not on today's agenda, but I will put it on the agenda for our next meeting, or maybe we would even need some kind of a working session.
Mhm.
That's probably a better format than a formal commission meeting.
And Mr. Chairman, I think what you may want to think about, you and your fellow commissioners may want to think about, is first, before we start talking about making these mandated changes to the forms, get the forms in a fashion that you think is appropriate. We noticed a few things about the forms this year. And I think in passing we said we're going to have to change that for next year, or this isn't clear, things like that. So let's get the forms in a way you're comfortable with, and then we can go ahead and edit the required changes into those new formats.
A question to council, or maybe to the clerk. What we have here is a draft of an ordinance.
Yes.
And I would expect the town, once we submit it, hand it to the mayor, here's a piece of paper for you. He would probably want to run it by the town's own council. So we may see changes from that level.
Possible.
Possible. Maybe not. I don't know. Maybe he trusts you.
The town attorney and I get along very well.
But in any event, that's not our decision. That's for the town to do.
Can I ask Fred
all right then, but
question for
yeah,
Fred?
sorry, Greg.
In the draft, page 2, I believe it is. 2B, 2527. Our person might not knowingly accept a gift. And then if you go over to E on page 3, list gifts in in the amount of $20. So I'm kind of.
Why? Uh, I'm sorry, what was the question?
Which is that you may not accept any gift, or you can accept gifts of $20 or less
As long as they don't add up
to
like,
over $100. Yeah.
cumulatively to $100. The way I'd read it.
You cannot accept under 2527B, you cannot accept, a covered person may not knowingly accept a gift from a person that the official or employee knows or has reason to know is doing business with the town or has financial interest, is engaged in an activity, or a new one that is an association, which is really either the Maryland Association of Counties or the Maryland Municipal League. So if it's not one of those persons, then there's no prohibition against accepting gifts.
Thank you.
And then under the content of the disclosure statement, you only have to disclose a gift in excess of $20 or a series of gifts from the same person or entity totaling $100 or more.
Got it. Thank you.
Oh, where are we now?
Oh, I answered the question.
Oh, yeah.
I believe I answered the
You
question.
did. Yes, you did. Thank you.
All right then. We are prepared to submit the ordinance, which would incorporate the state's mandated changes submitted to the powers that be at the town. So that concludes agenda item E as Roman 4E, develop an action plan for the previous subjects. We already agreed on an action plan with respect to the mandatory changes. And I'm not sure what the best procedure is to follow up on the changes that were generated by this commission itself. I had a discussion with the mayor about this. He was encouraging. He says, "We don't want this to die. Bring it back, and so we can take it back with those modifications that we agreed on." What I thought originally I would do is take the piece of paper that shows the previous proposal, and it seems to exist only in hard copy. I haven't been able to find an editable Word format electronic copy. And there is a Word style copy which the the town has, but it is in the format that the town seems to use for all its legislation. It's in all capital letters.
Right.
And
All capital letters for new
for
material.
new material, correct. And there is there also is a word version of the whole thing.
I believe, maybe I'm wrong, that if you go to the town's website and get the the ethics ordinances on the town's website, that I believe is editable. If you were to copy section 25-3 and then paste it, and then you
Well,
can edit it from there.
I don't want to have to retype the whole thing,
No, I'm not suggesting that you retype it.
but
You're saying cut and paste it, basically.
we'll have to do another search then with Sharon's help to find the editable version. It must exist somewhere.
Well,
it's
Do you,
it was the Exhibit B to Phil Keats' working papers that he submitted to the town, but I've only been able to find hard copy of that.
just bear with me for 1 second. No, I can't do it on my phone. But Sharon, am I correct that the E-code that's online you can work with it, cut and paste it, and then be able to.
For the E-code 360,
Yeah.
I can look at it, print it out, but I can't edit it.
Well, I think what I'm
I mean,
asking is,
and in order really to get into the E-code, you have to be an authorized user. You need a
no,
password.
no, I just got into it on my phone.
And the ability to edit.
No, I can't edit anything on my phone.
Okay.
Well,
Well, I can bring it up on my. I don't even try on my phone. I can bring it up on my laptop. But it's, what I can get is not editable. But it can be edited. I mean, the E-code is some kind of a service organization for municipalities, it seems.
Well, it's put out by the publisher of General Code.
Yeah, and they do what law book publishers have been doing for generations. They collect the various statutes that flutter out of the State House and put it into a coherent code.
Sharon, do you know whether you can download sections from the town code on E-code?
I would assume.
Yeah, I think there's a way to do it.
Actually, this is something I had asked for a little working session
We'll
afterwards.
talk,
Uh,
Sharon.
Yeah, this is the kind of thing that I wanted to get into, so maybe we can put that off, and for the purposes of this meeting, leave it that we will work out a technical, hands-on way of presenting the mayor and council with those sections of the ordinance that we want to change. Where we were to incorporate the self-generated changes.
One
And
of
that would get us done with agenda item E. We have a
Peter,
very
if I may-
brief one. Item F, review required annual certification to the State Ethics Commission. We received a reminder very recently. Oh, I'm sorry.
No problem. I just noticed that there was one other item under C that we did not discuss, and that was the issue about HOA members. Is that something we need to discuss and clearly indicate? Because there is a situation.
That was discussed in an earlier meeting, and it never led to a clear resolution. It came up because a citizen had a beef with her homeowners association, and she complained to the ethics commission and said there's an ethical problem here. It turned out that the people heading up the homeowners association are also elected officials. There are two of them.
There are actually three, I think, from our association.
The way the issues shaped up is that the complainant wanted to force those two people to get off the homeowners association. And we said, well, we cannot do that. You have to go to your homeowners association. They probably have procedures how to impeach and kick out some of the managers, but don't come to us. And if you insist that these two people resign their council memberships, then you have to go to the council. We cannot, ethics committee cannot remove them. And then the matter sort of died down, and we never.
And that is how I recall it as well. Yeah, it just
But,
died. Yes.
So we never got to that issue, but we could look at the ordinance. A suspect organization is one which is under the authority of the town, and nobody wanted to make a clear decision or make a clear statement whether a homeowners association is an entity subject to the authority of the town. I suppose you could argue yes or you could argue no, but we didn't get into that.
My understanding is our HOAs are governed by the state laws, and they're not under the jurisdiction of the town.
Well, they are for purposes of zoning and land use,
Okay.
and there may be specific town regulations that govern the operation of the association and the community. But the internal workings of a homeowners association are, you're right, governed by the Maryland Homeowners Association Act, as well as the Declaration of Covenants and bylaws of the association.
I guess from the purpose of the commission, the ethics commission, for our purposes, I personally do not see any difference in terms of being a member of association, which I am, of the same association where the council members are from, versus not, meaning that I do not believe being a director or a part of the HOA board of director is a reason of a conflict of interest. What I mean by that is that they obviously have an interest for the community they live in, the same way that I would have in a community I live, regardless of the position in HOA. So I'm not sure if the distinction for HOA is even warranted. HOA directors was warranted for any of these discussions.
It came to our attention and we did due diligence, I think.
Pardon?
It came to our attention and we did perform our due diligence. Yes.
Well, if I may speculate on the mayor's position on that, seeing what he has said about recruiting volunteers and so on, homeowners association and their managers, directors, officers, they are sort of a natural reservoir of people who, virtually by definition, are willing to engage themselves in, the public town matters. And yet, I've heard it expressed in a derogatory way. They're the busybodies, and but to find volunteers to do things for the town, you are looking for busybodies. So is this a subject that we should take up? And I suppose what we would then have to do is clarify, amend the ordinance by stating that a homeowners association is deemed to be an entity subject to the jurisdiction of the town. Or we could say, in order to avoid any ambiguity, an entity subject to the jurisdiction of the town does not include a homeowners association.
Directors of, yeah. I think if we wanted to be explicit, that would be probably my suggestion, that we be explicit. But there is no need to do that if there are no issues to be addressed. If the issue is gone.
No, several months ago, it seemed that there was an issue. And right now, my preference would be to let sleeping dogs lie.
Yes, okay. Very good. Thanks.
If a controversy comes up, we'll deal with it then.
If I may, if there were a matter to come before the town involving the homeowners association and a council member or a high-level staff person was a member of the association, or particularly an officer or director of the association, then I would expect that they would not participate in that matter before the town.
They need to recuse themselves.
Based on the general avoidance of conflict of interest.
Sorry, Council, do you feel that the code that we have, the ethics code we have, does indicate that, meaning that a director of an HOA is obligated to recuse himself or herself?
It doesn't talk about HOA specifically, but it's an organization, it's a corporation of which they are an officer or a director. And if, I forget what, we went through this a little while ago, the 3 or 4 tests. If there's a matter involving A, B, C, or D, then they would have to recuse themselves.
So it sounds like we're adequately covered that area specifically.
I think it is adequately covered without spelling out homeowners association.
Which, right.
Homeowners association is just one subset of a much larger group of organizations.
Very well. I think the council.
Do nothing.
Right. It's already covered.
Is there any other additional matter for discussion? Agenda item G. I think we just did that.
Did you deal with F?
F.
You started to, and then we
Any
got
additional
sidetracked.
matter for discussion?
Pardon?
And the homeowners topic is an additional matter so that
I know,
No
but
more on that, but I think we may need to talk about F.
the annual
on the
certification.
agenda.
You were
I'm
started
sorry.
talking,
Yeah,
and then
yeah.
we got sidetracked.
F. Sharon gave us give everybody the correspondence that we received from the state. It includes. No, it does not include. At least my copy doesn't. The form of the certification that has to be sent to the state. Yeah, I have that form here, and if anybody wants to have a quick look, historically it contains two certifications. The first, that the current ethics code for Chesapeake Beach includes conflicts of interest provisions for elected local officials and candidates for local elected office that are equivalent to or more stringent than the requirements for state elected officials as set forth in the citation to the law. Secondly, further certify current ethics code of Chesapeake Beach includes financial disclosure requirement for elected local officials and candidates for local elected office that are equivalent to or more stringent than the requirements for state elected officials as set forth in the law. And traditionally, it has been signed by the chairman of this commission. So I will be the one signing. There's also a questionnaire which includes names and addresses of the Ethics Commission. So it will identify the three of us, name and address. And they also want to know the most recent amendment of the local ethics law that would, at this point, be the ordinance as enacted in 2020, because I think between now and the deadline, there probably won't be any more amendments, depending how fast or slowly the council will act. And but we can submit this form prior to the deadline. Can we not, Sharon? We don't have to wait to the last day. So we can, add the dates and let it fly.
Yeah, Sharon, a question. I'd like to ask Sharon a question. Sharon, I saw that in 2020, Phil had sent the ordinance to the state and got pre-approval. and then sent it back for final approval after it was adopted. Do you know, did the State Ethics Commission ever give final approval after adoption? I don't have anything in my files. Okay.
No idea. Off the record, it wouldn't surprise me if we never received final approval from the state. There are what, 50 odd municipalities in the state of Maryland?
154 and 24 counties.
Oh, so I just had the county number, not even. Theoretically, they all should have an ethics ordinance.
Yes.
And the poor folks in Annapolis who have to review all those, they'll be busy until they're all ready to retire in a couple of years to do this review. On the record again. So Sharon, what's your answer right here now? I have to look. I don't remember. Is that your answer?
As to whether or not they sent anything, I'll have to go and look back in the minutes.
All right. Does that satisfy your question for now?
Yes, sure.
I think we'll discuss that.
Back to item G. Is there anything else other than the HOA subject? No. Next regular meeting, agenda item H.
The next meeting, the working session for the form, is that what you're considering?
I would prefer not to have it between October 16th and 20th, because that's early black powder deer season.
Seventh?
That's not good for me. I have another meeting.
Planning and zoning commission.
Pardon?
I might be at planning and zoning commission day, but it's.
I have a meeting at noon
Thursday.
that
He's got a
day.
meeting anyway.
So- We're going to November?
November 4th? I'm sorry, November 3rd?
November 3rd would not work for me.
That doesn't work for me either.
The following week,
It have to be on a Thursday?
No, it could be on any day as long as I don't have something else going on.
But
But
the,
we do ours during the day, so I should be good.
but the 9th, 10th.
10th is good for me.
No, 10th is not good for me.
About the 9th. 9th's not good for you, is it?
Or 8th or 9th. No, that week is actually pretty good. So 8th or 9th. would
9th
work
works.
also.
9th works for me.
Okay, 9th at 1 o'clock will work for me.
What was the date?
The 9th of November?
9th of November. 1 o'clock again. Agenda item I, last one, comments by commissioners and members of the public. Are there any comments? Today, we will experience the autumnal equinox. It will happen precisely at 3 minutes before 9 p.m. today, Eastern Time. And after that, the days will rapidly getting shorter. But the good part of that is in a mere 3 months, they will become longer again. And then summer will be just around the corner.
Does the equinox affect your hunting?
Recall reading 3 minutes before 9. Always changes a little bit, and I think it has to do with the fact that this globe we are rotating on is undisciplined and it wobbles a little, which is quite disconcerting if you think about it.
Okay, so we're talking about November 9th at 1 o'clock.
Yeah. Okay, November 9th at 1 it is. All right. Thank you all. Been a pleasure. And we must make sure to schedule one of our meetings for Shrove Tuesday, so we can all drink.
Mardi Gras.
That's Carnival Day. But you don't have to be Catholic to.
Are we adjourned? Are we adjourned?
The meeting adjourned.
Munich is adjourned.